Facts are supposed to determine the case. 10th juror. Don't give me any of that. I'm sick and tired of facts. You can twist them any way you like. Know what I mean? 9th juror. That's exactly the point this gentleman, he indicates the 8th juror, has been making. Why are juries required to render a unanimous decision rather than a majority decision in most criminal cases? To what extent, if any, do jury trials ensure due process as stated in the Constitution and Bill of Rights? To what extent, if any, do jury trials reinforce founding principles? You may begin, please.
The doubts of a single juror are evidence that the government has failed to carry its burden of proving guilt beyond a reasonable doubt. Justice Brennan's dissent in Apodaca v. Oregon, 1972. Unanimity seems like an unnecessarily high burden. Louisiana and Oregon both agreed, permitting non-unanimous jury verdicts under the guise of efficiency. But at the core of our justice system is the idea that a defendant can only be guilty beyond a reasonable doubt, implying that all jurors must view them as such.
Historically, states have used split jury convictions to target minorities, reinforcing the importance of unanimous juries. For example, the Louisiana Constitutional Convention of 1898 created a facially race-neutral law permitting 9-3 verdicts to ensure that African-American jury service would be meaningless. These Jim Crow-era split juries made it easier to imprison recently freed African-Americans for convict leasing to plantations. Both of these rationales were used in Ramos v. Louisiana 2020, where the court incorporated the right to unanimous juries to the states. However, we disagree on whether this should be retroactively applied.
Non-unanimous juries are also directly in conflict with the concept of due process outlined in our founding documents. The Constitution ensures due process in Article 3, Section 2, Clause 3, which protects trial by jury in all criminal cases. The 6th and 7th Amendments reinforce this through guarantees of fair and impartial juries in these trials and juries in civil cases.
An integral part of due process is equal protection. However, flaws within the justice system limit such protection, preventing true due process as stated in the Constitution and the Bill of Rights. The main issue is that juries do not adequately represent a cross-section of their communities. As legal scholar Mary R. Rose explains, juries across the United States are often highly unrepresentative of their communities, especially for the young, poor, transient, and racial minority populations. Complete due process is impossible if juries are not representative.
At the inception of our Constitution, the founders did not account for these flaws. They emphasized the biggest advantage of jury trials, that juries serve as a direct check on the government by the citizenry. As stated in Federal Farmer 15, 1788, through juries, people are enabled to stand as the guardians of each other's rights and to restrain by regular and legal measures those who might otherwise infringe upon them.
However, since the founding period, jury trials have been diminished, untethering them from our founding principles. According to a 2019 Department of Justice study, only 3.6% of criminal cases go to trial. That's compared to 20% in 1940. An over-reliance on plea deals, which account for over 90% of all cases, has led to a direct reduction of the checking power of juries.
Another crucial founding principle was that juries served as a form of participatory democracy. As Richard Henry Lee stated on October 12, 1787, it is essential in a free country that common people should have influence in the judicial as well as the legislative department. Despite the intent to involve citizens, juror apathy remains an intervening obstacle. For example, a 2010 investigation by NBC News found that only 23% of people showed up for jury duty in Manhattan in the 90s. However, there is a pathway back to the founding principle of participatory democracy through comprehensive legislative reform to make the process more inclusive and democratic.
Unanimous juries are just one important feature of the jury system. And while juries play a crucial role in the justice system, bias and inequality have dangerously distanced them from founding principles. We must fix these strains so that juries can once again serve as checks on the government, re-anchoring their role as the bedrock of American democracy. Thank you.
Thank you. You indicated in your testimonial there are some flaws in the jury process, particularly inadequate representation. Have you considered some remedies or solutions to those flaws you have acknowledged?
Because there are so many flaws within the jury and the justice system, we would like to separate each step of the process and address the flaws within each. Specifically, we would like to address the flaws within juror summons, voir dire questioning, and the trial itself.
First, we must increase accessibility in juror summons, and the way to do so is by increasing the amount of juror lists that we use. Manhattan, since the 1990s, has implemented reforms to improve its summons rate, specifically by expanding the number of lists it uses to include things like voter registration, taxpayer lists, unemployment recipients, and so on. And since the 1990s, has experienced about a 15% increase in its summons rate till 2020, demonstrating that increasing lists can increase accessibility.
Next, when looking at the voir dire questioning, we need to look at the peremptory strikes and seriously reform their use. This is what Arizona attempted to do in House Bill 2413, which stopped the usage of peremptory strikes in order to stop possible discrimination from entering when selecting potential jurors.
Lastly, we need to help the jurors themselves while they're going through the process. Right now, according to a Taking Law into the 21st Century study in 2005, they found that jurors only understand 50% of the juror instructions. To help jurors come to a better conclusion, we should allow them to ask judges questions during the instruction period.
Thank you.
Let me, I guess, sort of related to that, it's an article of faith among prosecutors, certainly, that a guilty defendant is more likely to want a jury, whereas a actually innocent defendant is more likely to want a bench trial. And I would say even many defense lawyers agree with that. Assuming that's true, or at least there's some truth to that, what does that say about whether juries really are a protection to that we want them to be to an innocent defendant?
Well, first of all, I don't know that that is necessarily true. In an American Bar Association study done in 2017, they found that both judges, the trial prosecutors, and public defenders found that jury trials were actually the fairest form of this process. And so I would believe that juries are a great opportunity. One reason why innocent defendants might lead towards guilty plea deals instead is because of the trial penalty, which actually means that when you go to trial, people are more likely to get longer sentences.
And even assuming that that is true, juries can still act as a check on the government through the process of jury nullification, which is when a jury rules against the law itself, even if the person is guilty of that law. For example, we see that juries have acted this way in the past through the John Peter Zenger trial in 1735, where the colonial jury protected the defendant, who was John Peter Zenger, who had published criticism of the British government and nullified the law itself, protecting Zenger in that case.
But isn't nullification just as likely to work the opposite way, which is that an innocent defendant is found guilty based on a racial prejudice on the part of the jury?
Jury nullification can end up being a tool of oppression. And this was actually seen in the Jim Crow South with the case of the murder of Emmett Till. It was a case where a Black man was murdered by two white men. However, these two white men's charges were dropped during their jury trial due to jury nullification. So jury nullification is an interesting tool because it could either be used to help those who are oppressed, or it could be used to oppress even more minority voices.
So I would argue that jury nullification would be best when the juror panel is actually most representative. So jury nullification, say, today would be more acceptable than when the Jim Crow South, when Black jurors simply could not actually be there. And we've seen jury nullification work today with Dr. Jack Kevorkian in 2002, who was known as the kindness killer. And he basically allowed for euthanasia and to help people the right to death. And they nullified his conviction because they believed he was doing the right thing.
Additionally,
I want to shift gears a little bit, make sure we cover more topics. So for the most part, jury deliberations are confidential. We don't know what's said in the jury room. Do you agree with that as a policy, or would you make changes to that default rule?
I think the secrecy of jury deliberations can be a tool that is that could help with unfair rulings. And I think this was outlined by Stephen B. Bright in his Georgetown Law Review journal, The Right to Counsel for Death Penalty and Other Cases. He spoke about how the secrecy of jury deliberations allows the prosecutors to be able to come up with a sentencing when it comes to plea deals, but it doesn't give the defendants nor the defense attorneys the same ability to know what is happening and the same ability to be able to know whether they're agreeing to a fair sentencing. So I think that there is some issue with the secrecy of jury deliberations.
I agree with you. With the secrecy of jury nullification, even though we are putting our faith within those 12 people, there can be a potential for juror abuse or other problems within that. And if we look towards the Equal Justice Initiative in 2020, they recommended having more independent agencies that would once in a while check these juror pools and see what actually deliberations are going on to ensure that democracy is being upheld and fair deliberation is being upheld.
I personally believe
I'm sorry, so how would that work when you say an independent agency check the jury deliberation? How would that work?
The Equal Justice Initiative stated for certain trials, you could have another individual person, just an independent agent, a person from the independent agency sit in on some of these jury deliberations and just to overview what's going on, not just to ensure that the jury is taking note of the correct things, but to also have a greater understanding of what actually goes on in juries to help with legislation in the future.
I disagree with this idea. I think having someone else sit in the jury deliberation room or have the government sit on the jury deliberation room would be a clear chilling effect. We need to let these jurors come to a conclusion on their own. And if we were to have people come into that room, that would actually discourage them from coming to a conclusion that they personally believe. And so in order to not violate their First Amendment rights, I believe that we should not allow people in that jury deliberation room.
Wait a minute, a jury has First Amendment rights?
The jury doesn't exist.
I think what Sienna is trying to say is that having a government official there would act as a chilling effect, essentially limiting the juror's speech because there is that person of authority present in that room. And we can see that the founders intended for juries to be common sense judgments. For example, Blackstone's Commentaries, published in 1765, advocates for juries to be based on common sense and not as much of a factual or law-based approach. And having that government official would restrict the ability for the jury to act in a common sense way and to truly converse with each other as common people.
If the jury is instructed and then nullifies, should the judge have some discretion or authority to overrule that nullification because of their failure to follow the law as given?
In certain cases, yes. For example, in civil cases, a judge can overturn a guilty verdict through a process known as a judgment notwithstanding verdict. And in this specific case, it can make sense, but this is very rare. And in general, we trust juries, even if the judge or the outer road may consider that decision to be the wrong decision. Inherent in our system is the idea that the jury is the final say on the case itself, and that no judge or external entity can overrule the jury itself.
There is also some harm in having the judge being able to overrule jury nullification. During the colonial period, jury nullification was used a lot by colonists in order to have their rights be maintained under the ruling of the British government. And a lot of the judges were sympathetic to the British. So if jury nullification in cases such as the John Peter Zenger trial were able to be overruled by the judge, then that means that the rights that the colonists tried to maintain for themselves wouldn't still be there.
And this precedent was actually established in 1670 with Bushell's case, where when they were trying William Penn, they found and the jury nullified, the court tried to punish the jury. And it eventually went to the King's Court, where they decided you could not punish a jury simply on the grounds for making their decision. And this was again—
How many of these rules should apply in civil cases?
You've been beaten by the clock. Sorry. I know you
By
were
the bell.
the opportunity to respond to Judge Levy's question. We'll have to save that for another day. Nicely done, well done. We applaud you. It is evident that you were prepared